Good morning. Happy Tuesday. For those of you who don't want to watch a 4.5 hour video of Lane shit in the bed, there are two main points I think you should take from the video, the live stream that I did yesterday. Number one is that Lane admitted to the judge when asked the direct question, did you want the other people to call on your behalf? Lane Myers said he did. That was at around 3 hours and change, maybe 3 hours and 9 minutes roughly into the video if you want to watch that. So to suggest that Lane didn't want people to call is, I think, immaterial. So he's kind of co-signing for what they said. He's co-signing for what they said. He wanted them to call. He wanted them to redress with her, a public employee. So that's a huge issue for a couple reasons. Number one, he said it, which means it's not hearsay, and he said it under oath. He's going to have a real problem if he tries to backtrack on that in his criminal case, because yes, the prosecution can use what he said in the civil restraining order hearing against him at his harassment trial, for the criminal trial. So it's a problem. It's a big problem. The other thing that is that I found to be particularly negative for Lane was that the whole thing about getting Lane's wife fired, all dubious, of course, but the timeline of events is how Lane Myers comes to this conclusion that the alleged victim got his wife fired. He sent the voicemail on whatever date it was. I don't remember the date it was. And then according to Lane Myers, 2 hours later, his wife was fired. For no reason whatsoever. She'd been given an award or something like the day before. So everything was hunky-dory in her job. Lane Myers sends this voicemail, this non-harassing voicemail, to the alleged victim, and 2 hours later his wife is fired. And from that, Lane Myers draws the conclusion that the voicemail to the alleged victim is the precipitating event to the firing, which means that the alleged victim must have listened to the voicemail, determined who Lane Myers' wife was, figured out where she worked, and got her fired. That's the chain of events. Tacitly in there, impliedly in there, is that Lane Myers is admitting he understands that his voicemail was harassing. Lane Myers, in Lane Myers' mind, is basically admitting that I sent a harassing voicemail. The voicemail was harassing enough that it incited the alleged victim to find my wife, find her employer, and get her fired within 2 hours of this email or voicemail. That's like, if it was just, as Lane Myers tries to pretend, just a voicemail, no non-harassing, just a voicemail, then why would that lead to his wife getting fired? It can't be that way. So the only reasonable way to interpret it is that Lane Myers understands his own voicemail was harassing. I mean, it's bad. And, you know, it was just a terrible performance on his part. He just spits out citation after citation after citation without explanation, without going into it. Why? Again, LaFaro versus Cahill was the best opportunity he had. It is undisturbed law, as far as I am aware, that says that the communication has to be directly to the alleged victim. Has to be directed at the alleged victim. The specific person that it's directed at has to be the alleged victim. In LaFaro versus Cahill, having it directed at third parties was insufficient. The judge got around it in the injunction hearing by citing two cases that were dealing with the criminal harassment statute, which I think is inapposite, but you know, that's going to be a determination for the Court of Appeals. But Lane should have argued that particular facet. I'm not saying that he would have won, but I'm saying that was his best argument that I could find. And he didn't do it because he's not good at this. He doesn't understand the things. He doesn't understand the law well enough to apply the law well enough to convince a judge, if that makes sense. And to kind of illustrate this point, I graduated from law school in I don't remember, 2000 or 2002. I don't remember. It's all a blur. I think it was 2000, right? I think it was 2000. I think I graduated from college in 1997. So yeah, 2000 I think is when I graduated from law school. It's been a long time. And I didn't do anything in the law for 16 years. I did nothing. And then one day I decided I actually wanted to take the bar and become a lawyer. So I bought a bar study guide for California. California Bar Practice Study Guide. Book about that thick. Obviously insufficient to the task, but I opened it up and I started reading it with the intention of grasping the things in it. And remember, I have gone to law school. I passed law school. I had like a B average or B minus somewhere in there. I don't remember exactly. It doesn't really matter. But I have a background. I had a background. And I opened up this book and it was saying words that didn't make sense to me. I couldn't understand it. And what really helped me, I don't know why my voice shot up there. So I got this book at the beginning of summer when I decided I was going to study for the bar exam in 2016. I read this book for 2 weeks, just going over it, trying to piece it together in my head. And it didn't make sense to me. And I was like, I have to sign up for a bar review course because none of this makes sense to me. I have forgotten everything and I don't have the basics down to be able to understand the concepts that are being discussed. And so I signed up for a bar review course. It wasn't Barbary, it was Kaplan. And it was an excellent course, and I did all the work in it. I mean, I did way more than I had to. I did every single one of the multiple choice questions. I did way more of the practice exams and the essays than I needed to. And I passed. And, it's great. But what helped, what got me over all of this was having someone teach me. Having the instructors break it all the way down and teach me. So not only did I have the book, the Kaplan study guide, but I also had the lecturers saying, all right, this is how it works. And then I was able to put it together. And also it was over the course of, I think it started after Thanksgiving and it ended in January. So it was 2 months probably, a 2-month course, 2-month refresher course. But anyway, but my point is you've got to know enough to know enough. And even though I've been active in comment sections, which is why I'm an OG troll. I've been active in comment sections. I cringe at some of my early stuff. I find myself having said things. I'm like, boy, you really hadn't thought that one through. That was a bad answer, or whatever, or you were just plain out wrong on this one. So, but back then, when I started, I didn't have the basic understanding enough to start building up towards the higher concepts and the understanding of the law and how it works. So I don't expect Lane to understand this stuff. And also there's a huge difference between something that you practice all the time. Criminal law, I am not nearly as good at as family law. Family law, breeze. I've got it basically on auto complete, just I can walk in cold, hungover, make an argument, probably get a good result. I don't do that, but I could. Criminal is a whole different ball of wax because I don't do it all the time. I've only done 2 or 3 criminal cases, so it's not something that's second nature to me. And so And so what I'm suggesting to you is that Lane Myers doesn't know enough to know what he doesn't know. He doesn't understand the concepts that he's talking about. He was flipping back and forth between 3 harassment statutes that didn't apply to his injunction situation. He'd never really addressed properly the fact that the definition of harassment was in 1809, 12-1809, and the court was improper to consider 13-2921. He wasn't competent enough to realize that the cases the court was referencing and the cases that the alleged victim were referencing were inapposite. They were dealing with the criminal harassment statute, not the civil harassment statute. He just didn't know enough. He didn't understand the basics of what a legal objection is, when to make it, and how to make it. I mean, he picked up relevance and beyond the scope from having the judge coach him on one, and then he was able to spit that out a couple times, but he never got a single objection sustained. His objections were improper. He didn't make evidentiary objections. I didn't cover it in the video, but the alleged victim wasn't authenticating her documents for like the first 2 or 3 documents. She didn't really authenticate. And the judge had to start prompting her, you got to authenticate your documents, basically asking her the questions that she would need to answer to authenticate the documents, because she wasn't providing the information herself. But Lane wasn't objecting to anything. He was allowing stuff into evidence in a fashion that I believe weren't properly authenticated. He doesn't know enough to know what he doesn't know. He doesn't know enough to be able to do his own research, to be able to defend himself. He really does need, this is basically a plea to the Lane Myers supporters. His defense attorney did an excellent job of representing him at the no bond hearing. He should rely on his attorney. His attorney may not succeed in getting him off the hook, but will do a much better job than Lane Myers could. And having a competent counsel might get a better plea deal, because the prosecution could look at this and be like, this guy, if he goes pro per, he's going to shit the bed. I mean, he's going to get the maximum sentence because he's so terrible. Why would I offer him a good plea? Whereas if there's competent counsel in there, well, now the prosecutor has to think, well, I might lose. There's a chance I might lose. So maybe I'll offer a plea deal that's less restrictive, that has fewer days of incarceration or whatever. So what I'm asking Lane Myers supporters to do for his benefit, I mean, it's going to remove a lot of my entertainment watching a pro se defend himself, but for Lane Myers' benefit, if you have any way at all to convince him to hire an attorney or to let his public defender represent him, please let his public defender represent him. Lane Myers understands that attorneys and have Lane Myers let his attorneys actually do the work for him. But Lane Myers understands that attorneys know more than he does. That's why he relies on his wife. That's why he cites back to his wife. My wife's an attorney. He knows that attorneys know more than non-attorneys do. He knows this. So this is all just a farce. And it's a farce. Like, he's gonna Eric Brandt himself into a bunch of jail time. So I'm pleading with you, basically, Lane Myers supporters, Lane Myers fans, people who have Lane Myers' ear, please convince him to use his public defender. His public defender did a great job. So I'm going to get off my soapbox now. I got a lot of work to do today because I had yesterday off. Thanks for watching. Have a great day.